Good evening, friends. Welcome you once again to the brand new episode of GICS Face Off, the Clash of Opinions. We all know that Supreme Court recognizes right to die with dignity as a fundamental right under Article 21 of the Constitution. Yet, a lot of legal uncertainties prevail among medical professionals and the patients, leading to difficulties in their implementation. Tonight, the subject before the motion before the House is, in the opinion of the House, the current Indian laws are insufficient for safe EOL practice in India. And to debate on this motion, we are joined by a panel of eminent intensivists from across the country. From the member of Treasury bench, we have Dr. Subhash Turi from Kolkata and Dr. Anusha Cherian from Puducherry. And in the member of the opposition bench, we have Dr. Prathima Ramchandran from Chennai and Dr. R.K. Bani from Delhi. We are joined also by our panel of jury, the Pradeep Rangappa, Kapil Dev Soni, and Ajit Eke. So without wasting any further time, I invite the first member of the Treasury bench, Dr. Anusha Cherian, to start the debate and present her point. Dr. Anusha.
My slides are visible?
Yes, please. You can
Yes,
continue.
okay, I'm audible. Yeah. Yes. So, good evening, everyone. And thanks to the organizing team for giving me this opportunity to speak for the motion on current Indian laws are insufficient for safe end-of-life practice. So it's a disclaimer that this debate is not against end-of-life care or the right of any patient to a dignified death, nor am I against it. Thankfully, we have crossed that stage. I am for the motion that current Indian laws are insufficient for safe practice of end-of-life care. So today I'm in a unique position as I'm arguing that current Indian laws are insufficient for safe end-of-life care practice against the very person and people who have dedicated the past decade to crafting those laws. Dr. Mani has been at the forefront of shaping India's end-of-life care guidelines, working tirelessly with the Supreme Court, the Law Commission, and medical bodies to create a framework where none existed before. So for his work, he deserves our deepest respect and gratitude. But tonight's motion is not about whether the work was well done. It clearly was. The motion is about whether the laws are sufficient for safe practice. And sufficiency is not measured by the elegance of legal language or the thoughtfulness of guidelines. It is measured by outcomes on the ground, by whether patients can safely exercise their rights, by whether doctors can practice ethically without fear, by whether vulnerable people are protected from exploitation. So when we say about Indian laws, the first one that we know of, the Aruna Schonberg case, it is a court order. Then we have policy documents from ICMR, then further Supreme Court orders, position statements, further orders from Supreme Court, which finally ended up in the Ministry of Health issuing as guidelines. So if we see these landmark decisions and timelines on end-of-life care, it's a set of guidelines or court orders that we have got, which finally resulted in the guidelines being issued by ministry. So in India, the way that legality has evolved around EOLC has been through case laws and judgments with the hope that they would finally make the law, because there is no corresponding Parliament Act for this. The problem with this is that there is a fundamental difference between laws, judgments, and everything else. So laws are basically rules that come out of legislative body to regulate conduct. They originate from legislatures, parliaments, constitution process, and it is to be applied to everyone within a jurisdiction, while judgments are the final decisions of a court proceeding or a controversy, and it could keep changing, it could keep shifting. So laws provide the rules that society must follow, while judgments are the application of those rules to a concrete dispute by a court. What do the other countries have as a framework for this? They have statutes, they have laws, they have codified laws as early as 2001. They have actual legislations, they have robust palliative care infrastructure, medical education, public awareness, accessible procedures, and clear legal protection for doctors. And why is there no law in India yet? from 1994, we are struggling. 96, Supreme Court outright rejected the right, include right to death. Then in 2011, they permitted passive euthanasia, but still required High Court orders. And then 2018, we had Supreme Court recognizing the right to death, but they made the the process so impractical that it was very difficult to practically see this fruit. In 2023, the further simplification of the guidelines occurred, and which resulted in the guidelines of the ministry. So we see here a timeline of failure. 14 years hence, patients still cannot safely exercise their rights. The judges are fearing potential that there would be a misconduct from the physician side. There is mistrust in the ordinary citizens and doctors, risk of misinterpretation. Then the societal and culture, like in India, along with legal ambiguities, there are societal and cultural unawareness of the need of dying. And mentioning death itself is taboo in many of our beliefs. So the diverse society and its cultural beliefs means that people are going to be dissatisfied at the treatment that they receive. And we are going to see further modifications of this current court orders. So what we need is a comprehensive legislation, not just court orders and guidelines. Parliament can hold democratic debates, reflect diverse cultures. Legislation can include culture and religious problems. Court guidelines cannot address the full complexity of the Indian diversity. So this has been done in other countries, so why not in India? So now coming to the safety aspect, is it safe for the patient? Is it safe for our healthcare professionals? I argue that it is still insufficient for a safe end-of-life practice for the patient because it actively endangers patient, creates an unsafe condition, exposing them to coercion, denying them pain relief, forcing unnecessary suffering, and leaving them legally vulnerable. Why is it a safety crisis? So many patients need palliative care annually, but many of them lack, majority of them lack adequate access to them. There is so many patients face end of life without proper pain management. Only 5.8% of palliative centers have uninterrupted morphine availability. Medical doctors are not trained in pain relief. So the patient is left with two options: either endure unbearable suffering with no legal framework for pain management, or request euthanasia out of desperation. It is not out of autonomy. So this creates a coercion by circumstance. Patient chooses death not because they want to die, but they cannot access pain relief. So if safe EOL practice requires patient to have access to alternatives, requires that patient has access to both alternatives to both suffering and death. So further complexities of the procedure especially during medical crisis, advanced medical directives we know are available. What happened to Dr. Nikhil Dattar? He himself had to file a PIL because when he went to apply for an AMD, there were several deficiencies that he faced. There is no clarity where to store it, inaccessible at the time of crisis. It requires establishment of a sound mind. If it is not if the patient is not of sound mind, then we have to verify that this AMD is true. They might need a digital upload as well. Though the procedures have been told that they are simplified, it still requires primary board creation, secondary board creation, maybe application to the High Court. And further, if they don't have an AMD, then further complications, even a division bench might be required. So we can imagine the kind of time delay that just prolongs the suffering of this patient, and many patients probably die before this process is complete. Further, information asymmetry. There is no patients, nor the doctors, nor the jurisdiction, any of us are aware of the availability of these options. We lack training in these. So this is an important patient safety risk because we have uninformed consent issues. We cannot make autonomous decision without knowing what our options are. It risks exploitation because families and doctors are taking the decision for patients who don't know their rights. And there are missed opportunities. Patients suffer unnecessarily because no one is telling them what are their alternatives. So safe medical practice requires informed patients. And when 96% of population don't know their legal rights, then those rights provide no protection. Further, there is infrastructural gaps that are there, which creates false choices. Without palliative care infrastructure, patients don't choose between life and death. They choose between unbearable suffering and death. So it is an important safety crisis it's like they either continue living like that or they request euthanasia. Autonomy requires alternatives. A choice between unmanaged suffering and death is not safe. It is desperation. So what about the international context? For in UK, for example, they have a strong NHS infrastructure. They have universal GP access, robust palliative care, trustworthy regulatory mechanisms. Patients choose euthanasia with access to pain management alternatives. What we have in India, fragmented, under-resourced healthcare system, which gives us no safety net. Terminal cancer patients requesting euthanasia because they cannot access morphine. Families are pressured to agree to end suffering because they cannot afford palliative care. So the patients are forced to take informed decision without actually knowing what is a proper end of life care could offer. Further social vulnerability, further leading to patient coercion. No universal health care means care is self-funded. No social security, family has to bear the financial options. No institutional support, so home care is the only option. Economic pressure eliminates genuine free choice. Economic coercion leads to family pressure. We all know of the Harish Rana case. For 13 years, he was in a vegetative state, cared by his old parents who were unemployed. They couldn't support him when they went to the court because he was not on a life support, no terminal illness they were denied initially. So safe end of life practice requires patients to choose death because they want to, not because they want to die, not because they cannot afford to live. So the current laws provide no protection against these forms of coercion. So the question before us is not whether India has made progress. We definitely have. The question is whether the current laws provide safe end-of-life practice for our patients. And the answer is an unequivocal no. When 96% patients dying cannot access pain management, we do not have safe practice, we have systematic abandonment. When, in spite of having living wills, we have to go through so many administrative barriers, this is not patient protection, but it's a trap that patients have to suffer through. When poor families face economic pressure to choose euthanasia because palliative care is unaffordable, we do not have patient autonomy, we have coercion by poverty. So my opponents may say that Supreme Court rulings are sufficient, but sufficiency is measured by patient outcomes, not legal documents. A patient dying in uncontrolled pain because morphine is not available is not safe. A family pressured by medical bankruptcy into ending a loved one's life is not safe. A living will honored only if you're wealthy enough to hire a lawyer is not safe. So a safe end-of-life practice for the patient would mean access to pain relief, informed choices free from economic coercion, having their wishes honored. Indian law provides none of these. It provides theoretical rights without practical safety. So the current Indian laws are insufficient for safe end-of-life practice for the patient. What about the doctors? They are liable to criminal liability, ambiguous guidelines, multiple boards needed for process, and ethical legal conflict, complex procedures with no legal immunity. Though the active euthanasia has been legalized, there is punishment for murder, culpable homicide, and mercy killing is equals to criminal offense. Though Supreme Court has legalized passive euthanasia, where do you draw the line between active and passive euthanasia? There is no clear-cut clarity. You could be an abetment of suicide or causing death. They could be misinterpreted various ways. No statutory protection for doctors acting in good faith. So the doctor's dilemma, when you're faced with a terminally ill patient, do you withdraw support? It is ethically appropriate but risky, or continue futile treatment. It is safe for you. So when legally safe choice is medically wrong and medically right choice is legally risky, the doctors cannot practice medicine safely. They can only practice defensively. So further in India in 2006, we had the Law Commission, which made some guidelines towards the best interest of doctors, but 20 years later, we still don't have any legislation. Medical Council of India has given some guidelines regarding brain death, and that too when a team of doctors is treating them. They don't protect the team either legally. So these are professional ethics, ethical obligation without legal protection. So further simplification of the process has been defined. But what happens if something goes wrong? Will the police come after us? Will the media go after us? So we have no protection here as well. So guidelines that tell doctors what they're allowed to do without protecting them from prosecution for doing it creates a legal trap, not a legal clarity. For the multi-board approval process, more procedures, more liability, more vulnerability. The simplified process involves extensive documentation. How much do we record? How little do we document? Can this be used against us? So multiple teams and doctors have a collective fear. Hospitals struggle to form these teams. A time pressure of 48 hours. What happens if we can't complete it in this time? Rushed decisions, errors. So these are the things that we face. What about ethical and legal conflicts? The Medical Council, as well as International Medical Council, they all tell us we should practice ethically or preserve patient autonomy, while our legal system tells us so many things that are bound to interpretation, not statutory, leaves the doctors vulnerable. So further, we have no immunity guarantee. There is no clear safe harbor, no statute telling you will not be prosecuted, no guarantee that police will not investigate. Civil, consumer protection, everything after us. No shield from professional misconduct. So what we actually need is clear statutory language telling that a medical practitioner who follows the prescribed end-of-life procedure in good faith shall not be subject to criminal prosecution, civil liability, or professional disciplinary action. What happens in the other countries, we can see that explicit legal immunity is given to them. So they have an established track record of no further, nothing happening to the doctors. Resulted in 72% ICU deaths preceded by treatment limitation, and doctors are able to have appropriate end-of-life decision without fear. What we need in India is to enact comprehensive end-of-life legislation with explicit immunity given in explicit language, shall not be prosecuted, will not be liable. We should have safe harbor, that a good faith protection. So it is the onus of the prosecutor that they have to establish a bad faith has happened, then only we can practice it safely. Clear procedures, standardized documentation with legal protection, professional body guidance integrated into the legal protection, mandatory training so that our competence is there so nobody can question us in what we do. So in conclusion, I say that the current laws are not safe for the patients. The current laws are not safe for the patient, nor for the doctors. Thank you very much.
Thank you, Dr. Anusha. Dr. Anusha has highlighted several important points. First, she said that India goes by now at the present current times by the judgments as against the laws. Most of the countries are following statutes and laws which are missing, and guidelines cannot explain the diversities that exist in the country as of now. She has talked about the patient safety crisis, particularly highlighting the inefficient and the inadequate pain management, which leading to requests from the patient for death out of desperation and not out of autonomy. The time delay that exists in the various processes and the timelines, the infrastructure gaps, the social, voluntary, and the the rights which she says that without any patient safety are of paramount concern. Active versus passive euthanasia has no clarity, and overall she has very strongly supported the motion before the house. And now we are going to listen to the member from the opposition bench who will contest against the views by Dr. Anusha, and it is Dr. Pratima Ramachandran. Yes, Dr. Pratima.
Good evening, everyone. Am I audible? Visible?
Yes,
Slides are
please.
visible? Okay. So thank you, Dr. Anusha, for helping me in this. I agree with Dr. Anusha in most of the things, except the last slide. So current Indian laws are insufficient for safe end-of-life practice. That is what the motion is, and I'm going to talk against the motion. So she did a very great help in listing out all the laws. I'm not going to go into all the past and old things. I'm sure that people will agree with me. I'm going to quote only 4 papers. I have listed the references at the end, and I'll be talking through this. And I'm not going to quote every reference. I'm just going to talk about what the problem is. So yes, there are very, very clear definitions. I heard Dr. Anisha saying that there is very, very small difference between passive and active euthanasia. Active euthanasia is a complete clear no. So we know that is not possible. But passive euthanasia is there, and withholding and withdrawing life sustaining treatment is equal. It does not have any difference. And advanced medical directive is very much there, and it is for the living who will specify treatment preferences by themselves. It is not only for dying, it is also for living. And even in case they want to go on full escalation of care, they can give it. Or in case they do not want to be on machines and futile life supports, they can say it as an advanced medical directives. We have laws for that. I'll be mentioning. So there was a clear confusion. Legal sufficiency versus operational delivery was the discussion. Legal sufficiency is not equal to operational delivery or the implementation. So we have sufficient legal, as you see and as you have seen, Dr. Anisha mentioned everything. So many cases were there, so many legal discussions were there, and this was happening. And thanks to all of them, now we have more and more clarity. Yes, we are Indians. We have a lot of cultural differences with the West, and we do think upon. We have a lot of emotional and cultural aspects. It is not very easy in India to just specify laws and leave it like that. So there is a national palliative care guideline which can be referred to. There is very clear definitions about passive euthanasia and advanced medical directive. So there have been legal milestones, as she mentioned, but I'm going to quote only three or four. So 2018, let us forget, or maybe we can look into those as a reference. But clearly, 2018 Supreme Court, this common cause article or the judgment is very, very clear. There is a right to die with dignity. Passive euthanasia and AMDs are legalized. So this has a very, very clear and extensive, comprehensive discussion, and clarity is very, very good in this. And our ISCCM has applied to ask about more clarity. She did mention that the complex procedure and how to maintain the medical boards, why primary, secondary, so many long time wasted in getting the approval. Now it is very, very clear how these constitutional benches have allowed us to decide. Still, it is yet to run in the parliament, but courts have asked us to check with them, or it need not be going to the magistrate straight away. There can be pre-appointed medical board in each hospital, just like we have ethics committee. So it is also made very, very clear from 2023. And that is the reference we can refer. 2023 is very later, so we have clarity in that also. So legal strength supporting sufficiency or much. So constitutional grounding, right to right to dignity under Article 21 is there, and procedural safeguards, dual medical boards, yes, witness attestation, revocation rights, everything are there because we are too safe. We want to be safe always. And as already mentioned by Dr. Anisha, she already mentioned that the care is spent by us. The care money is spent by us. So we need to be very, very safe. We have a lot of emotional attachment that nobody can say no. We have lot of cultural differences. We hold on to people. We live in families. So this is quite difficult because there are a lot of people involved. West might be very few people, or just one or two who are already legalized guardians or the surrogates. Here we do not have that. In 2023 streamlining, the notary attestation, reduced experience thresholds, and 48-hour decisions are made because we do not want to delay that. More than 48 hours sitting and looking at people not giving approval is more cruel than it is not a hasty decision. 48 hours had been set because there had been instances when it has been prolonged more than that, and the patient as well as the family went through a very hard phase in deciding what to do next. So this is also in the reference article, and I'm again and again quoting this streamlining order of 2023, which is very, very clear, and you can, if the audience want to refer it online, also it is freely available. So, what are the opponent claims and legal reality? It is two different things. So, they say that the laws are vague. AMD and passive euthanasia are clearly defined. It is not like we do not have advanced medical directives. It is not very difficult. If there is a surrogate going and applying for an advanced medical directive, if the patient is himself not very clear, it is difficult, definitely. But nowadays, advanced medical directive can be done before anything. Even in case of diagnosis, the patient that person himself, I cannot call him a patient as such, but the person himself can get it registered. There are many legal help for that. Passive euthanasia is clearly defined. Nobody is going to hold the doctor liable, or the criminality word was used. So that is not going to be done, and doctors will not feel pressurized if there are going to be clear awareness of laws. Not many doctors, I can agree, and to be very honest, there is a lack of awareness between the doctors and the hospitals as to how to go about this. And in case we run more and more awareness programs, and when they get more aware, they work closely with lawyers and the appropriate people involved in these expertise, then they will be clear, and the pressure will reduce and the criminality goes down. It is with the best intention of the patient things are being done, then it will be very comfortable, and it will be very legal to feel. So process is impractical, and it is not impractical, it is more practical. I have already mentioned about the 2023 reforms, and the it is simplification is already there. So we are almost there, and there is a risk of misuse. Yes, that is why we have put multiple layers of safeguards, and oversight definitely exist. I agree, but it is not to make the law very unapproachable, or to make it very difficult. It is the risk of misuse and safeguards which is had made it multi-layered. Yes, and this is also in 2018 Common Cause article. So implementation gaps are not legal gaps. So as I already mentioned, it is more of the holding on to cultural things, and not letting go because of emotional aspects. There is no implementation in advanced medical directive where it is available. It is not after the patient gets sick, the advanced medical directive has to be done. It is like an insurance. So insurance is actually before the disease, but once the diagnosis is done, the advanced medical directive can be done when the person is well informed, his sensorium is intact, and he is able to take very clear decision. Clarity of mind is very important. So due to protection against misuse, there are a lot of other layers, but it is only for safety, and that does not mean that it is going to affect the dignity to die anytime. So policy support is always there. There is a big national program for palliative care itself. So there are clear definitions, and the legal insufficiency is not equal to the health system capacity. We have a lot of very nice laws, very clean laws, which help in the end of life care, but there is a very little awareness and implementation among the healthcare system. So there is a study, palliative access study, India, which can be referred to for this. So I again mentioned low palliative coverage is not equal to law failure. We are not doing this. It is a health system issue because we are paying ourselves from our pockets. There are not lot of options which we are giving, and in case we sign for a conservative or a palliative care, we are afraid that the insurance will not hold. That is not what the legal system needs to be blamed for. We have good laws. We need to be making more implementations, and the hospital board should take it very seriously. And among the society, there should be more awareness happening. So, fear of misuse, there are judicial safeguards, and we have to make sure that that is also protected. It is very, very important. And for the physicians, it is protective. Nobody is going to call them criminal if they have good awareness and training. And these AMDs are very rarely used, and they are not because of the legal change, they are because of the awareness again. So, I say that laws are sufficient and rights based. Focus must shift to the implementation, and strengthen the palliative care. And we need to go ahead and make more debates like this so that people are aware about the AMDs and the end of life care. And healthcare providers needs to be trained. There should be more of social workers who are looking into this. And it has to be very, very clear that the law, they inform, and they make sure that the people understand laws define AMD, and passive euthanasia is there, and clarity really exists. So more and more awareness situations, more and more awareness classes, sessions, discussions will make it more comfortable and clear to choose what they want, and it will not be considered a crime. When my previous speaker was speaking, it sounded like we are discussing about some major crime which is involved in a lot of terrorism and killing. No, it is a dignity to die. Everybody has the dignity, rights for a dignity, and there should be a very good respect. And the term good death is already there. Nobody can deny that. And 2023 reforms, there are simplified procedures, impracticality is addressed already. So not to worry, we might be coming up with more and more some simplified procedures that will be very, very, very thin, and it won't be so heavy and difficult for people to understand. So safeguards will exist. I want to continue those safeguards. There should be multiple levels of question. Of course, we write multiple exams to become consultants. It doesn't mean that we are going to, we want to be safe for the patients. We all intend to be safe. But the thing is, there might be some layers added, yes, but we should find out a way how to just go through that without delay of time. I of course understand that, but safeguards needs to be there. And implementation gaps, I again say, they are not legal flaws. Our laws are sufficient for end of life care situations, but it is the implementation gaps. We should concentrate more on implementation awareness and policy frameworks than looking at laws and saying it is not yet sufficient. We have to make it sufficient. I really proud that ISCCM had gone and they had asked for clarity, and 2023 was that reform which had made it more simple and clarified. So it is not like we have to go always through the government to get the advanced medical directive or the end of life care approved. It is, if the hospital has a pre-existing end of life care committee, then that is okay. That is what they say in the 2023 reforms. But the parliament law is yet to be passed. But if it is safe to practice what the 2023 reforms say, so it is very important for to call for delivery reforms and not the legal overhaul. So that's where I end this, and this is a full list. I have quoted only 4 papers, and this is enough for us to give a very good clarity about the current situation. In case we want to know about the previous, how these were formed and what made us go through all these, come to or decide on all these, is history, and we can always go through that and salute the people and whatever efforts they have taken. Thank you.
Thank you, Dr. Pratibha. Dr. Pratibha has highlighted opposed the motion, saying that the members of the Treasury bench have confused between legal sufficiency and failure of operational delivery or operational insufficiency. She highlights that the advanced medical directives, the NBCC guidelines are all very clear. There is nothing to consider that they have no clarity. 48 hours have a definite reason, and it is the patient's family's convenience, she says, that for which it has been kept. She says that the laws are already were clear and defined, and the 2023 reforms have further simplified. There are certain cultural factors which can be addressed to. Some safeguards has to be taken, and if it is created more awareness, then definitely it can be successfully read that there is no such legal deficiency. The laws are complete and full. And now we are going to hear from the member of the Treasury bench, and it is Dr. Subhash Todi. Sir.
Can you see my slide, Anirban?
Yes, sir.
Okay. Well, thank you, Jess and Anirban and Pradeep. I think Anusha made a very valid points and rightly counteracted by the opposition. You know, when Dr. Mani is there, it is almost futile or it is inappropriate to debate on this subject. But we'll just try to highlight some of the things. One of the disclosure is I was part of the panel of this 23 Ministry of Health and Family Welfare position statement on this. But something which I thought might be coming forward just to make a point and how to even more simplify the whole thing. First of all, the terminology, you know, the right to live was not equal to right to die. So, but right to live with dignity. So that means that one has right to die if it's not dignified life. And that has been a confusion there. suicide, abatement of suicide. Again, is it a abatement of suicide that we are doing? Even judiciaries are little confused on this. The term euthanasia has got a very misconception among the public, whether they are not aware of active versus passive and all those kind of things. And at one time, euthanasia was, mercy killing, basically. And that's why I think this term should not be used, and which has been used even in the judicial forum. Now, withholding and withdrawing of life support, ethically, legally, in all documents, it's an oblique, withholding and withdrawing. But in a practical term, honestly, I have not seen so much of a commotion against withholding as opposed to withdrawing. Even the hospital administrators, they are not that concerned about withholding. We do it every day, and no boards and nothing. And that is where I think we need even more discussion. Advance directive has been pointed out, and this durable power of attorney is not very clear among the community. And this words of substituted judgment, when we talk with the family, they have to take a decision on the best interest of the patient, is not very clear. What exactly is meant by this term to most of the people? So these are the certain, I just wanted to highlight the terminologies which are a bit confusing. And you see the stakeholders. First of all, we should remember health is a state subject. So the centers can pass laws on things, but states will have ultimate the say on whether to implement these directives given from the center. The bureaucrats and the administrators, they play a very big role, especially in the withdrawal, and that's where it might vary from even hospital to hospital. The lawyers, the community, the people need to play a role in this. The surrogates, the doctors, and other healthcare workers, which we don't give so much of an importance, like the nurses and the other healthcare workers' opinion on withdrawing and withholding. We kind of restrict ourselves to the doctor's opinion, which might not be a very correct way to go about it. So those are the flaws, I think, in the present system, which might create an unsafe environment. Now, I will just read a part of this document just to tell you what is the evidence based on this. These are exceptions in the sense that there is always a risk in our country. So they have specified that it is in our country that this withdrawal may be misused by some unscrupulous person. This is from Supreme Court, who wish to inherit or otherwise grab the property of the patient. Considering the low ethical level prevailing in our society today and a rampant commercialization and corruption, we cannot rule out the possibility that unscrupulous person, with the help of some unscrupulous doctors, may fabricate material to show that it is a terminal case with no chance of recovery. There are doctors and doctors. While many doctors are upright, there are others who can do anything for money. Just look at the evidence. George Bernard Shaw's play, The Doctor's Dilemma. The commercialization of our society has crossed all limits. Hence, we have to guard against the potential of misuse. Look at the evidence. Robin Cook's novel, Coma. In our opinion, while giving great weight to the wishes of parents and others, we cannot leave it entirely to their discretion whether to discontinue the life support or not. And I think this is the crux. This is the root cause analysis of all these primary boards and secondary boards. I think these are exceptions rather than the rule, what has been mentioned by the Supreme Court. Has there been any surveys? Has there been any studies? How common are these things? This has come from, I think, this organ donations, unscrupulousness things and things like that, which has been taken into our withdrawal of life support. So that was kind of my thinking on this. And now coming to these documents which have been talked about, this primary boards, secondary boards, the flow sheets and the algorithms, which are, I think, is an advancement. We fully agree on that. But how much is it doable? Well, who's going to the secondary board members? It is different from a brain death declaration. It's once or twice a month. But this is almost in an 80-bedded ICU. We'll have patients like this, 8 or 10 patients almost on an everyday basis. So who's going to give time? The members of secondary board, more than 5 years of experience, who are going to reimburse them? And they are just not going to sit in a room and declare that this is okay. They have to go and see the chart. They have to go to see the patients. So how practical is it? And if it is so, then how many times it is being done in our hospitals needs to be audited. I think it is very important. And this, like for example, this was just published, I think, the last month or so. So SCCM guideline. There is no mention of any of these boards and things like that. More time on palliative care. This is the document which even I have practiced while working in the West. Level 1 therapeutic support level, do everything except CPR. 2 is do everything, including CPR. 2 is don't do CPR. Third is this, and then comfort measure. Just don't do intubation and things like that. At that time, we just had physician signature. When I brought this form to my ICU, I added signature of next of kin. It was not there in the Western document. It's that the doctors and the patient, we take decisions every day. So this is a similar decision between doctors and patient's family. No signature was required, just documentation in the notes. So legal ambiguities are there, lack of clear definition, inconsistencies across states, ethical framework is still not very clear, cultural influences. It's a heterogeneous society. We have so many religions. Everybody will have a different say. Often the family is given significant authority over end of life decision which may not align with the patient's wishes. Advanced directive has been talked about. Next of kin and hierarchy. What I have, my experience is the next of kin or hierarchy in our country is who is paying the bill of the patient. That person becomes almost the surrogate decision maker, because whether to continue, not to continue, one has to pay the bill of the hospital, and that becomes a problem. Judicial oversight, the judicial delays, and like for example in West Bengal, till now we don't have a nodal officer to whom one should inform, and that makes the administrator not to form a secondary medical board for withdrawing of life support. They are okay with the brain dead declaration, but withdrawal of and withholding life support, no way. There is nothing this sort going on in the hospitals. Inconsistent medical practices, training deficiency. Anusha has pointed out we are not trained into this. Resource constraint. Many of time it is because of the economic constraints and all. One has to withdraw support, and who's going to support the family in these situations becomes a big problem. And socioeconomic disparities. There is no clarity if there is a discordance. Now, we all agree that if there is a concordance between family members and doctors or within the healthcare workers, one can go ahead. But what about if there is a discordance between this? Then the guidelines and the frameworks are a bit ambiguous on that. So I think as a whole, I would fully agree with Anusa's the statements, and I would like Dr. Mani's comments on how to simplify it further. Because I think, if you have to do a survey and see today, it's been a year now, the new Ministry of Health and Family Welfare guidelines have published. Only few states have already implemented it. But in the real life, at the ground level, if you take a survey of, say, 100 ICUs, how many of them are doing this on a daily basis? Then we will know the success of this. And apart from that, what is we have so many quality of life scores. We don't have any quality of dying scores. So, just not withdrawing or withholding. How is the patient dying? Are we looking at it? What is the quality of death? We talk about the quality, but how do we quantify it? Is there any objective way to know the quality of death? That also becomes very important. So that area needs to be worked into before we have implement a safe thing. So these are the stakeholders. And I think this from death to eternal life is probably a dignified death is the one what is being meant by this slogan. Thank you.
Thank you, sir. Dr. Subhash Todi has highlighted the terminologies which are a bit confusing. She has also given a brief, read the guidelines of the Supreme Court, initial guidelines where it was mentioned the unscrupulous doctors, they support unscrupulous people and it may go all to waste, which led to the primary and the secondary boards. He has spoken about how difficult it is to implement the secondary board regarding they fulfill their reimbursement practices. There are legal ambiguities, there are other cultural differences. The AMD is not well advertised, as he says. There is a questionable A on the next of kin, and he says that in practical purpose, the one who is paying the bill is to be considered in India as the actual kin. He also cites the lack of nodal officer as in West Bengal. So that cites that this situation can exist in the other parts as well, because after all, it is the responsibility of the state to implement it. Only the center can draw the laws. And at a ground level, the poor level of implementation clearly shows that the law itself was weak. So now we are going to hear again from the member of the opposition bench, our last debater, Dr. R.K. Mani sir. Mani sir.
Thank you, Anirban, for this opportunity to put my views. And I heard the fascinating presentations of Anusha, Pratima, and Subhash Todi, my dear friend. Now, current Indian laws are insufficient for safe end-of-life practice. It's not all laws, not all Indian. It is a polite but firm and unambiguous no from my side. Now, this view I share with Pratima, of course. Yeah. See, perfect sufficiency. When we talk about sufficiency, we want a perfect one. Before we start to do something useful, we want some very, very perfect law. Okay, it's a utopian construct. And laws will always be insufficient in medicine if our values and clinical integrity are insufficient. We are talking about many aspects, many dimensions of medical care. It's not just the law. We can't implement the law separately from our clinical practice. What governs our clinical practice? Is it wisdom or perfectionism? Perfectionism is a disease. It's an OCD, right? It's the wisdom that we want to translate into action by the bedside. Now, there are legal principles that are established by Supreme Court. And this is a big paradigm jump in the legality that governs end-of-life care. The court unequivocally establishes that an adult patient may refuse life support even if it results in death. In persons who no longer retain capacity, withdrawal and withholding of life support may be done under certain conditions, and they have defined them, of course. AMD that meets specified requirements are legally valid documents. This is also a big quantum jump. We never had this right before 2018. And for incapacitated patients, not that everybody must have an AMD. In fact, even in the West, where AMD is well established, only a minority have AMD. Majority have, the principle of shared decision making between physicians and legal proxy or next of kin. Multiple physicians should be involved in the decision making process. This is what our law says. And active euthanasia is not lawful. Active euthanasia, passive euthanasia are well defined. And I agree with Subhash that it's confusing passive. So our recommendation from the medical world, ICMR, there is an ICMR definition. And all those terms which were requiring definition are there. The best interest and terminal illness and what is withdrawal, withholding, all that are there with a consensus document with the ICMR. So that is available in the ICMR website. Now we talk about safety. Now, see, Anusha said it's not safe from the patient's point of view. I mean, safety from what? What we are having a bone to pick with the law is it is overkill of safety. Okay, as Subhash pointed out, there was that strange suspicion of the entire medical profession for the notional idea that they may be conspiring with the family to do the patient in. How many of you have seen this happen? Huh? We're all intensivists practicing for decades. Now, I have not come across a situation where I'm asked to do the patient in. If the patient has to be done in, why bring to the ICU and put on the ventilator in the first place? Now, these are notional and unrealistic ideas which we didn't do enough to argue against. As a professional body, we should have argued against this notion. As a society, we should have argued against this notion because there is a bigger elephant in the room. Bigger elephant is the lack of safety of over medication, over technological aggression, right? This is what we are addressing. So this is a very one-sided safety. The potential for misuse, then there is no useful law which doesn't have a potential for misuse. Okay? And we have not at all given even a passing glance at what is the utility of this end of life care. This is immense, overwhelmingly more than the potential for misuse. There are layers of safety, because of this prejudice against a profession that they are commercial and they will do something unethical. In fact, it's already going on, the unethical practice, because there is no option of withdrawal and withholding. That's why majority of the time there is disproportionate treatment. And that's why there are two boards. There are two boards of safety. Now, how can two boards not be enough? Okay. And then for AMD also, you need two witnesses, notary and gazetted officer. This is a watered down from 2018 requirements. So as I said, safety is unbalanced. What do we want to achieve? We want to ensure appropriate care of the dying, especially to eschew iatrogenic burdens. And this is what you see every day in every ICU. And this is the vicious cycle we want to break. And that is what is causing people to go below the poverty line. 40% of people go below the poverty line to one ICU admission of one member of the family. The extraordinary procedure in ensuring safety has in fact put obstacles in delivering appropriate care in practice. So there is a trade-off. You can't have such safety that it precludes all appropriate decision. That can't be helpful in medicine. Whose safety? Another thing is for the physician. Now, no law can ensure safety for the physician unless there is a balanced EOLC decision of three aspects. There is the ethical, clinical decision making within the framework of the law. Law is only one leg of the tripod. It isn't the sole one. We are focused obsessively just on the law and legislation. No, you can't wait for years for legislation. We had the 196 report coming out in 2006 as a draft bill, but it never saw it even tabled in Parliament. So you can't be having a notional aspiration and then ignore the needs of your patient by the bedside. Safety of the physician lies in clinical soundness, ethical groundedness, and compassionate communication. Why are we not talking about them? It's not the sufficiency of the law, it's the insufficiency of our attention to ethical soundness, clinical wisdom, and compassionate communication. And then meticulous documentation. Documentation is very weak. So you can't blame the law. Law will look at your documentation. And if it is sound documentation, you are reasonably safe. There can only be a reasonable safety of your practice. There can't be a perfect safety. It all stems from over defensiveness. We want to be safe from the law. We don't want to be passionate about ethics. We don't want to be passionate about holistic care of the patient or ensuring dignity and comfort of patient while he's dying, and 1/3 of the patients die in the ICU. And how are we to care for them? That is the question we have to ask. Okay. We always boast as a quality marker, patient and family centricity. How can you be patient and family centric if you're not addressing the issue of appropriateness of what you do, and then move over to palliative care at the appropriate time, not at the point, just at the final hour of death? This is a quality marker in the ICU, and it's a primary responsibility of caregivers to be providing end-of-life care within the framework that's available to us today. We can't be postponing that to a mythical situation where everything is perfect for you. Because surveys of multiple ICUs across Europe has shown in this paper, famous paper, that on the basis of questionnaire to nurses and doctors, 23 to 28% of the patients are perceived to be receiving disproportionate treatment. Okay? Death has become dystopic. This is the way we are shorn of dignity. We're dying alone amidst these beeping machines, separate from our families, and then nobody is looking at it. Are we doing appropriately or not? And this is a clinical decision. This is the clinical question. We can't be looking at our lockouts for this decision. You know, Randall Curtis is a big name in critical care, because he's a pioneer of palliative care integration to ICU. From early 1990s, he's published many seminal papers. And he died. We lost him, unfortunately, in February 2023. And before he died, he produced his last papers. You know, one was an editorial, another one was a paper called Hospital Culture and Intensity of End-of-Life Care at 3 academic medical centers. We quote USA as having a very sound, legally sound structure. However, in the USA, the 3 academic centers of different ethical climate and default intensity of aggressive treatment. Okay, very different. And where the default aggression of treatment exists, there very poor end-of-life care decision making, very less frequent withholding decision taking. So it is a law. It's not on the law that it's all dependent. It's depend on how the physicians have evolved themselves and how they communicate. So you see, all this form the ecosystem, the national culture, the institutional culture, institutional policy, clinicians and patients and family, national policy. So this is a work in progress, and we can't be stopping just at the law. It's a work in progress at reform to all these layers of ecosystem. You see, we did our best to find some kind of legal framework to work with. We don't have a perfect one. It's a work in progress. We have evolved over 20 years to come to this point. And this is the 2023 January judgment, which gives us a framework which we can work on. And if you're determined, we can use it. Because I am using it in my ICU. I am taking 3 or 4 withdrawal decisions as well have become very common. Now, initially there was resistance locally from the administrators and the colleagues, but now it's become a matter. So this is what we have to have a champion in each place, and we can work with the same laws, and we don't need too much documentation. There's a 2-page document, that's all. And we have got 2 boards. There is a primary board coming from the treating team, and a secondary board where you have 3 other physicians, and then we'll come to how we manage the CMO appointee. Now, but then you can have a standing committee of the secondary board. Now, the 48-hour limitation is the reasonable upper limit of approval for the secondary board. It's not that you have to spend 40 hours. You can spend it in a few hours. So if you have a standing committee and you have got a system that is well-oiled and functioning every day, then you can accomplish these decisions very reasonably in quick time. So following up on the January 23 decision, the ISCCM IAPC made this collaborative guidelines or position statement for the Indian intensivists. Now, this is a well-researched document, and again, we had a Delphi process to accomplish certain statements and opinions, and then there is a 10-step decision-making pathway for end-of-life decision. So the safety for the patient is inbuilt into this pathway, and this is being used in my ICU every day. The issue is, it is very much part of your ICU practice. Okay, you must prognosticate accurately and thoughtfully, and be as frank and as honest and as compassionate as possible. And what is the intervention? Intervention is communication. Okay, you can see in the late 19th century, the painting shows a very compassionate, empathetic communication, non-verbal communication of the physician with the patient who is dying. But now we have more time spent against the LED screen, right? We are not even facing the patient. So we must improve here. We can't be looking to our law codes to improve our end-of-life care. The improvement comes from our daily communication with the patient. Communication is a way to elicit information about the patient as a person, provide the family with information from ourselves, medical information, and to support the family emotionally in making those decisions. I agree with Anusha. Autonomy, just by a law, you can't ensure autonomy. Autonomy is ensured by empowering the patient through our communication. The doctor must come to the level ground with the patient and family and value the patient, value the patient's personality. These are not time consuming, but these are attitude transforming practices. So there can be good cheer around in our midst now. We don't have to wait for a legislation. We don't have to wait for too much improvement in our law, which will take time and which is an evolving process. But as of now, we can ensure in our patient comfort, company, culturally significant activity, location of choice. They have to be moved to the home. You can do so properly, looking after the palliative care. You don't have to send people lama. Now, no court has allowed any lama. Okay, it is our practice, which we have made it a daily affair. So we can't be hiding behind laws and law. We have to be looking at ourselves in the mirror, what we are doing to the patient. What are we doing as a physician? Are we fulfilling our duties? Conversations with the patient, spending time, not abandoning the patient even after an end-of-life decision made. You have to spend more time. You have to use conversation as a therapy when your curative interventions have failed. Implementation is the key. Pratima pointed out so well. It is not the legal flaws, which are there. There is no perfect document. But implementation, this is again depends on the individual physician. It can't come through a law. Individual physician must understand, be passionate about the care of one's patient, the holistic care, the humane care, the humanization of medicine in the ICU, and how to be appropriate in our care. The appropriateness question one has to ask oneself first. Many states are starting to implement. The Supreme Court had cracked a whip. They've asked all the states, why is there no implementation of January 23 judgment? Now, Karnataka government has made a very comprehensive rule, and it allows dignified death for the terminally ill. What it says they'll put in place a system by which the district health officer will appoint a member of the secondary board. But pending that process, okay, It is not the flaw in the judgment, it's flaw in the implementation. This is across the board for all Supreme Court judgments in our country. So it is not unique to EOLC. So it gives you an alternative. It's ordered that any neurologist, neurosurgeon, surgeon, anesthetist, or intensivist who has been approved by the appropriate authority to form part of the board of medical experts for certification of brain death shall be deemed to be nominated by the district health officer. This is what we do in our ICU. Okay, we have got those members forming the secondary board, so we are able to implement. We have got 6 physicians signing. We have got members of the family signing. See, we can't be always looking at the exceptions. Okay, in some family there may be a conflict and all. Then you have to resolve through consensus, through conversations. No law court can resolve that. That is for your area of activity, your area of expertise. So this is what we do. I know it may not be applicable in UP. But pending what UP government's rules, you can follow. It is not against the law to follow the ruling in another state, and which is consistent with the Supreme Court judgment and with the professional position statement. So these are all the safety for ourselves. So we can't be overly cautious about our safety. That will be detrimental to the care of the patient. So to conclude, I must say, what is really needed is a cultural shift in the ICU care to foster an ethical climate. Even in the US, it's the ethical climate that drives appropriate end-of-life care, not the law. A change must come in physician practice and attitude. We must think of the dying also as requiring specific care away from aggressive technological care. There is no need for technological fuss in certain group of patients. This we know as clinicians. It is our call. We need to train in several palliative care competencies, right? We can't just wait on palliative care departments. There are general palliative care principles and training which we all intensivists must acquire. And this should be part of our competency training. And as a society, we must actualize the provisions in law for EOLC. Further simplifications will come only if we implement the existing law. You can't wait for absolute, workable solutions. We have to wait. We don't have to wait. We can implement what is feasible, what is possible right now. Thank you very much.
Thank you, sir. Thank you very much. Dr. Buddy has highlighted the point saying that the perfect law is a utopian construct and perfectionism is a disease. So there is nothing called perfect law. So, and implementation of the current laws is very much easy. It ensures safety to both the patients and the doctors. It ensures safety to the patients because it has 3 layers of safety, 2 boards, followed by including CMO and also countersigned by a gazetted officer or a notary officer. It is safe for the physician, provided physician is clinically sound, has ethical groundness, and has compassionate communication. For them, it is also safe. He also says that disproportionate treatment is leading to dystopic death, and there are reasons to follow it. He also says that the 2-page documentation is enough. There is nothing big, and it has already been clarified. And what is required is to change the ethical climate. Now, before we move on to the jury, I request the debaters that if anyone needs time for rebuttal, we have 2 minutes for any debater if they want to do any rebuttal.
I fully agree with Dr. Mani on his statement. The question is the ground reality of hundreds of ICUs that we have in our country. It might be okay in some of the tertiary care ICUs, the ivory tower ICUs, but what about so many secondary ICUs? I think that is where most of the inappropriate treatment, the prolonged treatment goes on. And there has to be a much more simplified way of withholding life support, which can be practical utility in these smaller ICUs. I think that is where I think we have to move ahead.
Correct.
Anirba, can I respond to
Yes.
that?
Okay.
You see, I think anything must start from the tertiary care center, because that's where maximum interventions are taking place. That is where maximum iatrogenic burdens are taking place. That applies to even curative treatments. Okay, in smaller places, curative treatments have more complications, but then we do have them. We do accept them. We do laparoscopic surgeries everywhere.
True.
So you see, you can't be one-sided in your safety. That's what I mean. It is safe to pile on an intervention, but not safe to withhold an intervention. That's not correct. That's not a view prevalent in our profession. That may be a lay person's point of view. We can't adopt that view. We have to educate the lay person. But what I can say, I went to Mathura for a few years, to establish a tertiary care center in Mathura. And I practice end of life care as well as I practice in Delhi. What I'm saying is, we spend time in communicating with the family, telling them the prognosis. And the human behavior, human suffering is the same. And human response to clear prognostication is also very similar. It cuts across, because you can't be having one rule for educated, another rule for uneducated, one rule for urban, another rule for rural. The common denominator is how to mitigate human suffering. There we are in one platform. And then the laws can't be separate for different levels of care. Laws can be only.
Yeah, laws can't be separated, but the implementation,
Similarly,
process of
our
implementation will be different.
medical principles
Yeah.
of end of life care and dignity in dying has to be same
See.
at whatever
Yeah.
level of care you are. But you see, the culture, the attitude, okay, that must change, and it will change only like this. Only if you start to implement. Okay, if you keep on waiting, then the change will come late, which is what has happened here. Changes in end of life care came in the 1990s. In fact, the laws in US came after 1970s. Yeah, it has taken us so many years. It's taken us nearly 50 years. So we can't be such laggards. There is hardly any 2 or 3 year gap between technological advances to percolate to even relatively small towns in this country. What about the ethical side of the care? What about the ethical framework? Should that take a long time? That should parallel
True.
any advancement. Now you've got robotics, you've got molecular. They all have to be within an ethical framework. They can't be do without it.
Absolutely. Fully agree. Anusha Cherian, your rebuttal. Yes, you are waiting for long. Yes.
Yes. So, with a lot of respect to Sir, he's been persistent in this. But we hear this that this is not the failure of the law, but it is like we should improve implementation. But implementation failures are features, it's not the bugs, right? So, it's been 7 years since the Common Cause, 14 years since the Arna Schonberg case. But if laws remain unimplementable even after a decade, then probably they are insufficient. Good laws will create their own implementation, right? So I think it's the complexity, like Sir said, it has simplified a lot, but we have to still go. And when I say safety of the patient, I mean that I see a lot of people coming from the lower socioeconomic status in my hospital who are forced into withdrawing support because of the financial economic
No.
thing, and because of
That is not
that
a.
kind
Yeah,
of
very, very,
ethically.
very good point.
No,
Very
no,
good
no.
point raised by
No, no,
Anusha.
I
That
must
if
answer
laws are
this.
good laws and they can't be implemented, then how do we know that
So
they're
I'm
good?
saying it should go
No,
together. We
I'll
can't
answer in two
silo
lines.
them.
Yeah, Anusha has got two good points. I must answer them. See, the first point is, if the law is sufficient, then it will be implementable. Not necessarily. You see, it needs the governmental structure. For example, to appoint an RMO for the secondary board, you need the government to inform the district court and the district CMO. So we are dependent on the government's infrastructure. So you can only implement up to the point that you are able with the current structure. So that's what we do. We had applied to the district CMO. He said, no, I don't have any instruction from the health minister. So if you don't have the instruction, it doesn't mean you can't implement. It doesn't mean you can't practice ethically until that happens. I practice ethically. I practice as what I have preached, and I have not got into any trouble. In fact, the the patient, the family relationship is so much better. I sleep much better, and I don't feel burnt out. because I'm able to deliver what I think for the patient. See, there are many barriers. And barriers are also opportunities. Barriers are not irreconcilable, structures. They can be worked around. So we have a starting point, then we work around. We know what to achieve, so we work around the barrier. So unless we raise a voice, the government is not going to put the structure. Secondly, you said poor patient. Now, poor patients not being able to afford is not a ground for end of life care, nor is it a ground for withdrawal. According to our own guidelines, we don't need the law for it. This is medical guidelines. We have to ground it in ethics, as I said. If somebody can't afford, you have to relocate to a place where they can. This is what we do. Okay? Government hospital, if you can arrange. If the patient is genuinely, terminally ill, then why do you want to make the patient spend more money? We do talk to the patient, ask what their desire is. That is what is respecting the autonomy is. You don't impose withdrawal. That is against your principle. That's not professionalism. So our challenge is professionalism. What we understand by professionalism and how do we make it happen by the bedside. And for that, we are not dependent on a perfect law. We are working at it. We are continuously working. For 20 years, we've been working at this law. There are many barriers in the society. Still, we have come to this point. So we have hope for the future. If we keep at it, we might get to a position where only one board is enough. Okay, that's what the idea. This is what we asked for.
Yes.
In the court, we argued for a single board. The government didn't allow it. The health ministry didn't allow it. It's not that the Supreme Court didn't allow it. They said if both of you agree, so this is a via media you got. Okay. Before you reach the peak of Everest, here's a middle level calls. No, you stop some places. You can't reach the peak right in one go. You reach in at several points you stop. This is what it is. You take it, but then the goal is same. Goal is to provide dignified death to your patients, and which is what we will get also when our time comes. So it is for all of us. This is what we have to realize.
So that's a well-made remark by Mani sir, that what gives comes back. So
yeah, exactly.
there is no doubt. So we had an excellent round of debate, and now it is time to give the verdict. We will move on to our jury. I will start with Kapil Dev Soni, and then I will move on to Pradeep Rangappa. Yes, Kapil. You have heard members of the Treasury and the opposition.
Yes, I have both sides of the story. I must thank all the speakers, specifically Dr. Anusha, Dr. Todi sir, Dr. Mani sir, Dr. Pratibha. They have done a fantastic job to discuss one of the most core issues which almost every doctor working in ICU faces in day-to-day life. And as Mani sir has clearly said that we have come a long way, means what 20 years back, and we look at today, we have much better condition to decide what to be done and what not to be done. But there is one still, Dr. Todi just highlighted what the execution is a problem, specifically related to the patient perspective, the doctor perspective. Those are still to be worked upon. There has to be a distinction between prolonging life versus prolonging death, and that is important. And second is about right to palliative care. Though we have end of life care, but the right to palliative care is still needs to be enforced in given the lot of disparity and geographical resource disparity in the country, that needs to be exercised. That's my take.
Our next jury, Dr. Pradeep Rangappa.
Yeah, good evening. So my salutations to Dr. R.K. Mani sir, who has really put in human efforts into this end of life, and Dr. Subhash Todi and all the esteemed speakers, Pratima and Anusha. So I have few submissions to make, and this is the revelations that I'll be making in a closed door. See, I think we heard the whole pros and cons. Why I believe the case law is needed, I will give you my own personal example. So I represent a state which has taken huge strides actually in end of life. I mean, Mani sir would be very much party to what is happening in my state. And in fact, I'm part of the SOTO committee. And I was a part of the special committee which was formulated, thanks again, Dr. Mani sir, because there was a court order sent out to every health secretary, because our current health secretary is Harsh Gupta, who created this particular committee. Every state, I'm sure, has constituted a committee to try and see how best a state can ease out this whole process, which Supreme Court has given an order. So that's all it was. I think R.K. Mani, I would love to hear his comments. And to this date, Karnataka is the first state which has absolutely simplified this process of LRT. And I take pride in representing the state which has simplified, because I was part of that committee. And I was part of the committee which asked me as to how we should simplify this from the Supreme Court order, primary medical board and secondary medical board. So this is what we told them. We told them we don't need to create any extraordinary gentleman from anywhere outside. It has to be within the organization. So as the order stands from Karnataka state, the order is primary medical board, secondary medical board is the same as organ brain death declaration committee that we have. Every hospital in Karnataka has this brain death committee, which is formulated, and there is one member in that. Like I am a member of brain death committee in my hospital, which is authorized by a SOTO. SOTO is State Organ Tissue Transplant. So it's very simple. So they said it is the same committee which can do the end of life. Which has, I think, from my understanding, we are the first state who said, we have agreed that we have absolutely simplified this process. I don't need any doctor, any casualty medical officer from government, anyone. My own doctors within my organization, we can create primary medical board, secondary medical board, and we can simplify this. So having said that, but I am facing another monster within my state. So hopefully we are all in a closed room. So the another monster that has emerged from this is, if I can say, it is the whole thing about the organ donation problem that we have, and this has created a huge problem for us, because what this has led to is a separate sort of a dimension, which I'm sure all intensives are up to, which is donation after dying. So the whole movement with Mani sir started with a very altruistic. See, I've been doing end of life since 25 years. I mean, from Australia, I've been doing. And so the 3 points I need to say. Our Karnataka has made it easy, but we are in a diabolical state. What is diabolical? I say diabolical because what end of life leads to is being interpreted as donation after cardiac death, which I'm sure is not the context that we are here to discuss. But that has led to a problem here. Problem for us in our state is the government is telling us, recently we had a meeting, the government is telling us, because the people's trust in this end of life is not problem, because there is an intent to procure the organs. So they have said this has to be, if the intent is to do donation after cardiac death, this has to be done in a governmental organization by partnering with us. The private body has to partner. So this has led to a whole lot of confusion. In fact, we are having meetings to try and represent these are two separate entities. We need to decouple these both. So that is the second aspect. The third aspect, which I want Mani sir to comment, because I have few case laws. I think I have a case law on myself on end of it, because I've been doing from 25 years. So there is one patient who has put in a sort of a litigation that these doctors in this hospital have withdrawn, although there is no end of life policy which is legal. So I was actually, in fact, I love to see that, because I wanted to argue on this. So despite our established trust that we create to do this end of life, there is a litigation that is there on me, saying that end of life has happened without, although we have followed the due diligence. But what I'm only trying to say is the trust factor is somewhere it lacks, because we have understood there is no precedent case laws that has come up which will make end of life legal. But I have a case law, but that has not seen any light of the day, because we have followed all the due diligence, and there is an absolute clarity that we have done it with patient's consent and so on and so forth. But still, they have put that as a clause, although there was a different, this was a subarachnoid hemorrhage in a vegetative state. The whole growth of the family was that the bone flap was not given to them during cremation. That's all it was. But and they know me well, and they have an absolute trust in me. But still, they have included this in one of their litigant points, that we have withdrawn life support, although it is illegal. That was prior to this Supreme Court. So these are the three submissions I need to make. We have made it easy from Karnataka. Having made easy, we have gotten into a diabolical state where government is interpreting it as with an intent to a pathway of procuring organs for cardiac death. And the third thing is no case law. I have a case law on myself where patients have litigated me saying that the end of life was done, although this rule or this there is no sort of a legal mandate for it. So these are my three submissions. So we are in a very heterogeneous country, and the beauty of India, they say, is heterogeneity, and maybe the evil thing about us is there's too much of diversity. So the best thing is diversity, and the bad thing is diversity. So this is what we are facing. So need valuable comment from Mani sir and Subhash Tori sir on this, because we are in a progressive state where we have taken a lot of initiatives, but we are in this sort of a situation where a lot of other things emanate, which makes these things not as easy as we think it is. Over to you, Anil.
You see, Acha, may I respond to Pradeep?
Absolutely, sir. I need your
You
valuable.
see,
Yeah.
you see the what did you say? The point number one is that yes, Karnataka state has taken a big leap forward. It's simplified the procedure, and this is what we have adopted here as well. And they have, this is what we had suggested in the Supreme Court at that time. Supreme Court didn't agree. They wanted a CMO from the district health officer. I mean, a representative from the district health officer. But we argued the point. But then I'm very glad that Pradeep was there on the board for advising Karnataka, and they have implemented a very, very useful suggestion. You can take the brain death committee members in lieu of a RMP from the district health officer. Number 2 point is about the diabolical interpretation of organ donation. That is technically not feasible because we don't have DCD protocol as of now in the TOA. We don't have, so we can't harvest organs from a withdrawal patient as of now. We are working on it. There is a group of us along with mostly transplant surgeons. We have appealed to the Ministry of Health. We are working with them to produce a protocol for DCD, and which will improve our organ pool. And for DCD, the recommendation is you must separate the withdrawal decision, WLSD decision from the from talking about organ donation. And organ donation consent is given before the death of the patient, not after the death. Before the death, while the withdrawal is being planned. So that will not hold any water. Now, Pradeep, another thing is we are liable to prosecution anytime. We are handling human beings. Whether you withdraw or don't withdraw, you are liable to prosecute. Whether you can defend yourself. We can now. The 2018 judgment with the professional guidelines, professional statement is a very big security in court. So I'm not worried about any litigation. I have not had any, strangely. I've been withdrawing and everything. But then we have to take care that we have a broad consensus within the family.
Thank you, Manu sir. In fact, I was happy when that litigation came to me because I wanted to argue this because I thought I'm the best person. I'm the best person to create this as a case law example.
Absolutely. And you can argue yourself.
Thank you so much, Mani sir, for very valuable comments. But the second comment about TOA, sir, I've gone through the TOA, which is Transplant of Human Organs Act. It came, which was amended in 2011. In fact, recently we had a roundtable meet just around a week back, where Dr. Anil, who is the director of NOTO, and there are few people who are taking ombudsmanship of legalizing. So they say that, I mean, when you read that law, it is not very clear. They say it is left sort of non-committed, whether it is, so it is left to the interpretation. So there is no very clear semblance of whether it is
donation
legal
after
or
cardiac
not.
death, which is, see, after withdrawal, you get a cardiac death. You don't get a brain death. So as of now, protocol is only for brain death. Can you find in the TOA, protocol for DCD? You don't. Although in defining death, they have not separated brain death from cardiac death. They say you can die from the cardiac side or from brain. But then there is no protocol for organ procurement out of
Yeah.
DCD.
So,
Here
so
you
what
got a
are-
full protocol. In brain death, you got all
Yeah.
the forms,
So-
everything.
yeah.
Yeah.
So what has happened, Mani sir, this is just in a closed door, the decision of our government is that all these DCDs after withdrawal should happen in a government hospital in collaboration with private. And they want to have this sort of an understanding for this way forward. That is our state think tank, which is
No,
thinking.
but the state doesn't have a protocol for DCD.
Yes.
The safety is in the protocol. Just
Right.
like brain death, there is safety in the protocol.
Yeah.
You may still do criminal things, but then there is a rule, no? There is a protocol. So protocol is in the making. I mean, a part of this system which is trying to create a DCD protocol in the TOA.
Yeah. Thank you, sir. Thanks so much, sir. Over to
Okay,
Anirban.
thank you, jury, thank you, all the evidence. So we are clear with at the end of the debate that we have gone significant advancements in the laws with regard to the practice of end of life care. True that it is not still foolproof. There are still lacunas left, and there are still ways to improve our current laws. But more than importantly, it is important improve our approach towards end of life, and it make it more amenable towards our patient, make it more safe towards our patients, and in their safety lies this our safety as doctors and as practitioners of end of life. Thank you everyone for being part of this debate, and we hope to meet all again our viewers with some interesting debate again next month on 12th of March. Till then, from all of us in GICS Face Off, the Clash of Opinions, Shubhratri, Shabar Khayat, good night.
Thank you, Anirban. Thank you, Mani sir. Thank you so much, sir.
Thank you very much. Thank you very much, Anirban.
Thank you, sir. Thank you.
Thank you. Thank you.
Thank you. Thank
See
you,
you all in
jury.
Chennai.
Thank you, my
See you all in
colleagues.
Chennai, sir. See you all in Chennai.
See you all in Chennai.
Everybody welcome, sir.
Thank you. Thank you, sir. Bye. Good night.
Thank you, Anusha.
Thank you, sir. Thank you, sir. Bye, sir.
Bye.
Bye, Anisha.
Bye.
Pratima.